afternoon to all of you. On behalf of BYJU'S Exam Prep, the most comprehensive preparation app for all exams, I, Shurojit Bhaduri, welcome each and every one of you for today's live session. So a very good afternoon to all of you friends. A very good afternoon to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. So friends, today we are back with another very important session on previous year's question discussion. So today we are going to discuss some of the questions which came in the previous year's question paper of CLAT. Now, since a student who is preparing for CLAT must and should have a decent idea about the previous year's question paper. Why? Because when you are preparing for an examination like CLAT, you should know what kind of questions did come in the previous year. So accordingly, you can prepare yourself. So insofar as your better preparation is concerned, we bring to you this amazing session. Okay, so guys, let's begin. But before we begin, BYJU'S Exam Prep brings to you a crash course for CLAT 2022 aspirants. So those of you who are preparing for CLAT 2022, BYJU'S Exam Prep brings to you this crash course for CLAT 2022. BYJU'S Exam Prep also brings to you a comprehensive preparation course along with foundation module for CLAT 2023. So if you are preparing for CLAT 2023, here is a fantastic comprehensive preparation course along with foundation module. Get yourself enrolled. So friends, let's begin. Up on your screen is a particular passage. Read the passage very carefully, understand the passage carefully, and then we have to answer certain questions. So read the passage very carefully. Okay, I'm sure that by now you guys are done. So this passage deals with the jurisdiction of courts in a contract. So suppose in a contract, two courts have jurisdiction. So by virtue of that contract, if one of the courts is excluded from the jurisdiction for a dispute, that is a valid contract. Let's read more about this passage. Okay, Are we done reading with this particular slide also? Are we done reading with this particular slide also, guys? Tell me. Okay, okay. Let's move on to the next slide. Okay. So, this passage deals with jurisdiction of courts in a dispute relating to a contract. Which courts will have jurisdiction? Can a party enter into an agreement whereby it takes away the jurisdiction of all the courts and confer it to a court which does not have jurisdiction? That is not done. That is not possible. Parties cannot by an agreement confer jurisdiction on a court which lacks the jurisdiction to adjudicate. Very, very important. Understand the passage. Up on your screen is question number 1. Okay, please give me your answers. Please give me your answers. Ishan says A. Hariom says C. What about the rest? What about the rest? The correct answer is option A. The clause relating to jurisdiction is a restraint on legal proceeding, but not an absolute restraint. Okay. So, two courts have jurisdiction. Okay. Delhi and Mumbai. Now, there is a clause in the agreement which stipulates that in the event that there is a dispute between A and B, the courts in Kolkata will have jurisdiction. Now, how does Kolkata feature? It does not feature anywhere. There is a dispute between Delhi courts. A person in Delhi and a person in Mumbai has certain disputes relating to a contract. How can they give a jurisdiction to a court which does not have jurisdiction? So the correct answer is option A. How will the contract give a jurisdiction to a court which does not have jurisdiction at all? Am I clear? Is that clear to all of you? So the correct answer is option A. Moving on to question number 2. Now, here is a person who stays in Chennai, the other person stays in Bangalore. And they decide that in case there is a dispute, the Chennai courts will have exclusive jurisdiction. This is a valid contract. So option D is the right answer. Is that clear? Option D is the right answer. Am I clear to each and every one of you? So this is how you should solve these questions, guys. You should know, you should read the the facts very carefully, the passage very carefully, understand what the passage is saying, and then it's so simple. It's not difficult at all. So guys, if you're liking today's session, do share this session with your friends. Do share this session with your friends and definitely do like the session. Okay, moving on to the next question. Question number 3. Now, can there be an agreement whereby the parties decide that even if there is a dispute, you cannot go to a court, none of the courts, neither can you go for arbitration or negotiation or conciliation for that matter, which is various process of alternative dispute resolution. In the event a dispute between A and B takes place, none of them can approach the court of law or take recourse to any alternative dispute resolution. So the correct answer to this question is this is invalid because it is a restraint on legal proceeding. So option A is the right answer. Option A is the right answer. Understand what the question deals with. It is not a difficult question. It is not at all a difficult question. All that is, you have to understand the passage and solve. Okay. Moving on to question number 4. How can Chennai courts have jurisdiction? Chennai courts cannot have jurisdiction in this case. Ahmedabad as well as Ranchi courts will have jurisdiction because A is a resident of Ahmedabad and B is a resident of Ranchi. A is a resident of Ahmedabad, B is a resident of Ranchi. Clause 6 says in the event there is a dispute, both Ahmedabad courts or Ranchi courts will have jurisdiction. Clause 7 says, no, not Ahmedabad, not Ranchi, but Chennai courts will have jurisdiction. How absurd. So clause 6 is invalid. Clause 6 is legal. So the correct answer is option B. Option B, clause 6 is valid. Clause 7 is void. Option B is the right answer. So this is how you must solve these questions. This is how you should solve the question, guys. Am I clear? Is that clear to each and everyone? Fantastic, fantastic. Question number 5. Which of the following is correct? Parties cannot, by a contract, exclude the jurisdiction of all courts. Very, very important. So option B is the right answer. You cannot, by a contract, exclude the jurisdiction of all courts. No, you cannot do it. That is what the passage deals with. That is what the passage explicitly deals with. Very good. Muji, Ishan Singh. Very good. Okay. Are you understanding how to solve these questions? Not difficult question, just that you need to read the passage and then solve the questions. Before we move ahead, BYJU'S Exam Prep brings to you an express course for Maharashtra CET, A-Lit, SLAT, B-Lit, Jamia LLB 2022 Batch 2. If you are preparing for Maharashtra CET, A-Lit, SLAT or B-Lit or Jamia for the year 2022, get yourself enrolled for this particular course. The next passage, passage 2. Read the passage very carefully. Okay, this deals with completion of a proposal or communication in a contract. Okay, okay, are we done reading with this particular slide? Guys, are we getting done with this particular slide? So we move on to the questions. Question number 6. Tell me the correct answer. Now, this communication of acceptance against the company is complete. However, since the letter was lost in the transit, it is not complete against the purchaser. It is not complete against the purchaser, mind you. So the correct answer is, which of the following is the correct answer? Tell me. The correct answer to this particular question is, tell me. Option, tell me fast, all of you. No, it is not A. It is not A. Communication of acceptance is complete against the company, but it is not complete against this purchaser. So the correct answer becomes option C. Option C is the right answer. Because the moment you drop that letter of acceptance, it is complete against you, but it is not complete against the proposer. Read this part. Communication of acceptance is complete as against the proposer when it is put in the course of transmission. So as to be out of the power of the acceptor, and against the acceptor when it comes to the knowledge of the proposer. Am I clear? So the correct answer is option C. Is that clear to all of you? Do not make silly mistakes. Read the passage very carefully. Once you read the passage very carefully, things will become easy. Question number 7. A, who is in Mumbai, makes an offer to supply goods to someone who is in Delhi via mobile phone. It has to be supplied in Pune and the payment is to be made electronically. So, what can be concluded from this? Where is the contract concluded? The contract concluded in, tell me, fast. Is it neither Mumbai, Delhi or Pune because it was telephonically done? Was it only Pune? Is it only Delhi or is it only Mumbai? The correct answer is option C. It is Delhi. It is Delhi where the contract came to be concluded. Am I clear? It is Delhi. Because the things would an offer for supply of goods to be. You give it in Pune, but it will come to Delhi. Question number 8. Yes, tell me. So, the acceptance email was read by the proposer at 7:05 p.m. So, the correct answer to this question is, as against the seller, it is complete at 4:04 because he has given it. But he read it. The email was read by the proposer at 7:05 p.m. So, the correct answer is option B. It is option B. Is that clear? Am I clear to all of you? Question number 9. Where is the contract concluded? It is concluded where Y stays the acceptor. Where does he stay? Jammu. So the correct answer is Jammu. So simple guys. These are very easy questions and I'm sure that you will be in a position to solve these questions. Very good, very good. Okay. Moving on to the next question. When the word of acceptance are spoken into the telephone and they are put into the course of transmission to the offerer so as to be beyond the power of the acceptor cannot recall them. In light of the given propositions, which of the following are correct? The communication being instantaneous, the contract immediately arises. Okay. The communication being instantaneous, the communication of the acceptance is immediately complete as against the proposer as well as against the acceptor. Fantastic. The communication is non-instantaneous? No. The communication is non-instantaneous? No. So the correct answer is B is the best answer. But, option D is also correct. Only 2 is also correct, but 1 is also there. So let's see. Option B is the right answer, but if you have marked D, don't be very sad. Okay? Is that clear? Is that clear to each and every one of you? Okay? So friends, I hope you enjoyed today's session. Thank you very much. BYJU'S Exam Prep brings to you a booster course on legal affairs and current events for CLAT 2022 Batch 2. Thank you very much. Do share, do like and do subscribe to this beautiful channel made for you guys. Thank you. Bye-bye.